Ladies and gentlemen, let me call this meeting to order of the Standing Committee of Justice and Human Rights, meeting number 62. It's Monday, March 4th. What I'd like to do just before we start the order of reference that's here in front of us with according Bill C-55 is just to we have the fifth report of subcommittee on agenda and procedure in front of us. It actually talks about us having this meeting today, so I think it's only appropriate that we pass this first before we start the meeting, if that's okay.
Actually, I was going to say it was really well placed because we might have a better idea at the end of how it's, because maybe the clerk will tell us how many witnesses.
I can tell you that right now, so if you want to know about from on this. So what is happening today, once we call the minister to order, to the meeting, not to order, to the meeting, sorry, Minister. We've had no witnesses requested by the Conservatives. We have had no witnesses requested by the Liberals. We've had 5 witnesses requested by the New Democratic Party. Of the 5 witnesses, 2 have confirmed. 1 is a high likelihood. We will be doing having those witnesses appear on Wednesday for the first hour. Okay. If we need a little more than an hour, this is only a 7-clause bill. No. Then we will go to clause by clause. We'll deal with it then, and then we'll be here on Thursday to present it back to the House. So we're waiting to hear from 1 more. 2 have basically, of the NDP requests, have declined. Okay.
Because they were not, we're aware that it was short notice, so right. It's not so much they didn't want to come and talk about the bill. It's more the time constraint that has been the major problem. So that I understand. And the 2 people that you say will probably be there on Wednesday, the Association du Barreau Canadien is not one of them. They just filed their report. Okay, that's 1 extra. It should be okay then. Okay. It should be okay.
All right. Thank you very much. And with that, I'll take a motion to accept our 5th report. It's been moved. All those in favor? And that carries. Thank you very much. Now, according to order of reference, Monday, February 25th, 2013, Bill C-55, an act to amend the Criminal Code. We have the pleasure of having the Honourable Rob Nicholson, the Minister of Justice and Attorney General, here for the first hour to talk to us about this bill, and he's accompanied by a number of senior staff members who will also be here and are willing to stay into the second hour if we have questions for them specifically. So with that, I'll turn the floor over to you, Minister.
Thank you very much. I'm pleased to be joined by Karen Odsent and Don Paragoff, both from the Department of Justice, and they'll be glad to answer any questions that you may still have, if you have any, after my hour here. Mr. Speaker, or Mr. Chairman, I'm pleased to be here to talk about C-55, the response to the Supreme Court of Canada decision in R.V. Say. It responds to the Supreme Court of Canada's decision in the Say case that found that existing wiretap authority to wiretap without prior judicial authorization in exceptional circumstances was unconstitutional due to its lack of accountability safeguards. Now, the bill before you responds to this finding of unconstitutionality in Section 184.4 of the Criminal Code by adding the safeguard of after-the-fact notification to persons who have been intercepted. 2, adding a requirement for public reporting on the use of this power. 3, a restriction for the use of emergency wiretaps to cases of serious offenses. And 4, limiting the use of this power to police officers and certain listed offenses. Now, under Section 184.4 of the Criminal Code, the police can conduct a wiretap without prior judicial authorization only where the situation is too urgent to obtain a wiretap authorization. The interception is immediately necessary to prevent harm to any person or to property, and the originator or recipient of the communication is the perpetrator of the harm or the victim or intended victim of the harm. This means that police can only intercept communications between the perpetrator of the anticipated harm and the actual victim or unintended victim of that harm. This imposes a strict limitation on who can be intercepted and closes the door on the possibility of police intercepting the communications of an unlimited number of class of persons. Furthermore, there must be an immediate need to wiretap to prevent harm to a person or property from occurring. This should provide you with a sense of the how and when this section can be used, for example, in situations such as kidnappings and bomb threats. Finally, the urgency of the situation must make it impossible for police to obtain an emergency wiretap authorization. To be clear, the Criminal Code has another provision that enables a rapid response designed for an emergency. Section 188 of the Criminal Code enables an abbreviated process for court authorization, allowing 36 hours of wiretap. For police to avail themselves of the authority under Section 184.4 of the Criminal Code, it must not be possible for them to seek court authority under either the principal and lengthier process for wiretap under Section 186 or the expedited process for short-term wiretap authorizations in emergency situations under Section 188 of the Criminal Code. That said, the Supreme Court in the Say case found that while there exists a justifiable constitutional imperative for the existence of such a wiretap power, Section 184.4 of the Criminal Code, as drafted, is constitutionally deficient despite the existing built-in safeguards that I've just described. And its reasons? The Supreme Court found that the addition of after-the-fact notification to persons whose communications have been intercepted would make the provision constitutionally compliant. That's what they told us. If you do that, it's constitutionally compliant. So, C-55, this bill, proposes this requirement for the use of 184.4 of the Criminal Code by requiring that notice must be given to the person within 90 days of the wiretap unless a court authorizes an extension. La Cour suprême du Canada a également formulé.
The Supreme Court of Canada also commented on other issues for which the bill also proposes some appropriate responses.
While the court held that the notification was the only amendment required for constitutional compliance, it expressed the view that reporting was a good idea from a policy perspective, and on that the government agrees. Therefore, this bill proposes to add a reporting requirement to the use of 184.4, which would mean that the reports prepared annually by the Federal Minister of Public Safety and Provincial Attorneys General on the use of wiretaps would now include information on the use of Section 184.4. This will enhance transparency and increase public knowledge and scrutiny of the use of this exceptional power. The Supreme Court also considered restricting the use of this section to police officers instead of peace officers, as is currently provided in the Criminal Code. And this could enhance charter compliance, though the court did not rule on this issue. Again, the government takes that representation and that suggestion to heart, and the bill, therefore, proposes to restrict the availability of this section from peace officers, a term which is defined rather broadly in Section 2 of the Criminal Code, to police officers, which is a narrower class of individuals. For example, the narrower approach would exclude those individuals, for instance, like mayors and reeves. This bill also proposes to limit the use of Section 184.4 to the offenses listed in Section 183 of the Criminal Code. Presently, the section can be used for any lawful act. That's what it says now. Although limiting the authority to this use this power to offenses listed in Section 183 of the Criminal Code was commented upon, this was not required by the Supreme Court of Canada. Nonetheless, C-55's proposal in this regard would harmonize this section 184.4 and its use with other provisions in the criminal code related to wiretap, which are already limited to 183 offenses. So we're making it consistent with the other wiretap sections that the laws that the provisions under the criminal code would apply to this as well. Harmonization with other wiretap provisions will also be achieved with the notification and reporting requirements that I've already mentioned, as these requirements already exist for some of the other provisions in the criminal code. Finally, I would note that the Supreme Court of Canada gave us until April 13, 2013 to amend Section 184.4 to address this defect, and that time is swiftly approaching. This makes it imperative that we move as quickly as possible to enact this legislation, failing which, after April 13th, police will no longer have the ability to use this section, which may compromise their ability to respond to high-risk situations and to protect Canadians. When considering the reasons for the amendments in this bill, it may also be of use to consider the situations in which the bill or the section is likely to be used. Kidnapping is one example, as in the Say case, where a married couple and a friend were abducted from their home and held for ransom. Police relied on this section to respond quickly with a wiretap when family members were contacted by one of the abducted persons. In another case of R.V. Riley, the police used Section 184.4 of the Criminal Code during an investigation of murder through drive-by shootings, where the goal was to respond quickly to prevent additional murders. These cases illustrate the importance of this particular section. In short, Bill C-55 is about ensuring that police have an important tool they need to protect Canadians, while also ensuring that it is used in a way that shows respect for privacy that Canadians can expect from their government. I urge all members to support this. Thank you very much.
Thank you, Minister. Our first questioner is from the New Democratic Party, and it's Madame Beauvais.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. Thank you, Minister. Of course, we're all well aware of the time issue. Of course, in R versus Say, the Supreme Court set until April 13th for us to do something, and something has to be done. The government had taken another avenue, if you will. You replaced C-30 by C-55. C-30 had been highly criticized, and the government didn't really act on that for a number of months, and that is why we here are at the final hour, must make a decision and consider legislation which is significant. You said it yourself. It's in a section of the Criminal Code, a violation of privacy-related section. So we're fully aware of what we're legislating on here. In looking at Bill C-55, I note that although the Supreme Court has not made a decision as to the issue of police versus peace officers, I appreciate the government, in its wisdom, not waiting and on this issue, but rather trying to circumscribe this issue. Of course, police officer is a police officer or any other person responsible for maintaining the public peace or something to that effect. I'm always a little allergic to these kind of catch-all phrases. What exactly do you mean by that, or what these other people who would be responsible for ensuring public peace, who these people would be? Are we talking about private security guards, or could it go that far? Could it be people employed to ensure compliance with other federal legislation like the National Defense Act, the Immigration Act, etc.? So perhaps if you could give us a better explanation of that, clearer. In response to the Supreme Court, perhaps you might have opened up another avenue there that might be complex.
Thank you very much, and I agree with you about better defining exactly who it is that can and should exercise these powers. The term peace officer is certainly an older term, and in many ways, if you went back and looked at the history in these areas, many times the mayor was called upon to exercise a certain responsibility if there was some type of uprising or riot. That being said, there is a definition within the criminal code that defines who a peace officer is. It would include, as I indicated, public officials like the mayor, reeve, sheriffs, deputy sheriffs, sheriff's officers, justice of the peace, members of correctional services, basically any permanent employee of a prison or a penitentiary, and officers under the Customs Act, Excise Act, officers under the Immigration, Refugee Protection, a fishery guardian, for instance, is included as a peace officer under the Fisheries Act. The pilot on an aircraft.
No, I'm well aware, Minister, so thank God that you are not going with that definition of agent de la paix. But when we talk about autres et tout autre policier, j'aimerais qu'on...
And all other police officers, I'd like to know what your new definition is. Does it go as far as to say, for instance, a security guard? What do you mean by that?
Security guards or mall cops or commissioners. I mean, it's those individuals that you're very well aware, Sûreté de Québec, Ontario Provincial Police, RCMP, municipal law enforcement agents.
Perfect. Now, the other part of the legislation that I question a bit, I'm not sure of the answer yet, is that vous parlez d'octroyer des prolongations.
Talk about granting an extension of a maximum duration of 3 years consecutive. But here it's a section where we're talking about exigency or urgency. Why would we extend that up to 3 years? It seems a bit too broad. And on that point, I'm trying to understand the logic behind this new provision.
Again, this is very specific. Again, what would happen immediately after after this type of wiretap has taken place, you would make application under the other two sections here, and again, those have complete judicial oversight and all the oversight, the requirements that are involved with the other two sections. Those are the ones that would kick in. This is for an immediate.
Okay. And lastly, my last question to you is, le Barreau canadien...
The Canadian Bar Association submitted a brief that's rather interesting, and they make a few recommendations as to amendments. That the discretionary power, exceptional discretion to initiate Section 184 for interceptions be limited to a class of designated superior officers. That seems to be well covered. Also, a requirement to be added to publicly report the number of persons whose communications were intercepted under 184.4 but who were not subsequently charged with any other offense. That a police officer's justification of Section 184.4 interception be recorded or memorialized, and if subsequent judicial authorizations are obtained on the same grounds as Section 184.4 interception, evidence obtained by the Section 184.4 interception may be ruled inadmissible. With respect to producing a public report on the number of persons whose communications were intercepted under 184.4 but not subsequently charged with any offense, would you object to an amendment to the legislation so that that report provided to Parliament on an annual basis be provided for all? Is that a yes or no to that?
That question, have you seen the...
Thank you, Madam Boivin. We're making the reports consistent with what already takes place with provincial attorneys general. They report now on the other two provisions in the criminal code with respect to wiretaps. And now what we're doing is making this consistent with that, with the additional safeguard and the additional requirement of the Federal Minister of Public Safety. And so, again, I think this bill is straightforward, and as I say, it goes beyond the safeguards that are required by the Supreme Court of Canada to bring it in line with the Constitution. We've taken it, as you pointed out quite correctly, a couple more steps, so we have put that in there. But again, this will be consistent with provincial attorneys general, and I think these are steps, considerable steps forward.
Thank you, Minister. Thank you, Madame Boivin. Our next question from the Conservative Party is Monsieur Gauguin.
And thank you, Minister, for appearing, and thank you for the witnesses. Pretty apparent that Bill C-55 seeks to, right the judicial oversight and basically make the interception of private communications constitutionally valid. And we know that in each instance there's a test that's done, and you strive to make sure that all legislation is, of course, in holding with the Constitution. And of course, we thank you for that. It's pretty apparent from our view of the cases that any interception of private communication would probably prima facie be a breach of a constitutional right against search and seizure. So, Minister, just generally, can you tell us what is the interception of private communication and why exactly is it needed in this society?
Well, again, we're told, and it's consistent with what we know about law enforcement, that this is a necessary part of dealing with some of the emergency situations that law enforcement agents come across. I see Mr. Wilkes and others would be able to tell you, instances where information of this type becomes very, very important. I indicated to you in the Say case and the other case where we have situations where people's lives are in immediate danger. I mean, these are the innocent individuals, the victims. And so it's absolutely vital that there be authority contained within the criminal code that will allow officers to go and intercept this kind of information for the safety and the well-being of those individuals. I mean, there's been a considerable history over the last 40 years with respect to this whole area of wiretap. And I believe in the 90s, Mr. Paragraph, you were there when having a look at a number of these provisions and basically updating them from the 1970s to be consistent with what's happening in terms of changes to technology and to the changes to what are being faced and met by law officers. But with respect to this, it's absolutely vital that there be something like that. If somebody's life is in immediate danger, for instance, and that's just one of the examples, you've got to have the ability to intercept that. But as we pointed out, there has to be safeguards on that because, as you quite correctly pointed out, people have the right to privacy and to know that their communications are kept private. And so this is why we have put beyond what the Supreme Court of Canada required on this particular section. We've gone beyond that, building in other safeguards and clarifying when and where and how this authority can be used. But again, there are the three sections. There's the regular section of the criminal code with respect to wiretaps, the emergency, and then this is that third category where they immediately have to have information. And again, what we're doing is consistent with what the courts and indeed what law enforcement officers have to have and what victims have to have if they ever find themselves in a position like this.
Thank you, Minister. The courts seem to do a balancing act between protecting the rights of the individuals against intrusion of their private rights, and of course intercepting their private communications, and of course protecting the public, and of course there's that intrusion into their civil rights. What about the situation of imminent harm? I mean, does the right of the individual give way to the right of the state to intervene to protect them? Why is it necessary to amend the criminal code to allow wiretaps in situations of imminent harm?
Well, again, it's always a balancing act that Parliament and the courts have in balancing the rights of individuals with respect to privacy and the right of individuals to live freely and without fear of harm. And so in those situations, and again, I outlined a couple of them, and you may hear from whatever witnesses that you have here, that where police come across a situation where somebody, for instance, is in imminent harm or that a serious crime is about to be committed, that if they intercept that, if they get information on that, that they may be able to intervene and protect the individuals or property that are being imminently threatened. And so one of the interesting things about the Supreme Court of Canada decision, say, when you have a look at it carefully, is that the courts agree and understand that on occasion this type of power has to be available to the police officers, and what they have said is, yes, we understand that's okay, that part's okay, but you have to do something beyond that to ensure that this is not abused, and that it is important that there be some clarification and some accountability with respect to this. And so what is done here is basically bringing it into line with other provisions of the Criminal Code with respect to reporting, narrowing the group of individuals for whom this applies to. And so, again, that's what you will see when you have a look at this, that, yes, we're complying, but we go a bit beyond that as well. I think it was important.
Thank you, Mr. Chair.
Liberal Party, Mr. Scapalagia.
Thank you, welcome, Minister, Mr. Mirgoff and Madam Audsan. I'm curious, private communication now, that captures much more than people talking on the phone, I would think, or so
Yes,
it would capture
Yes,
email.
yeah, that's
and,
right.
Yeah, everything. Okay.
Yep. Conversations within a room, for instance.
Right. Okay. I'm interested in. Well, you answered. You answered the question from Madame Boivin about the definition of police officer, and that's only obviously recognized officers from recognized police forces, municipal, provincial, RCMP, and so on and so forth. So that is clear. Then is what you're saying is very clear.
I think so. I think we did is just more carefully define exactly who it is that we're talking about. Even with respect to limiting this section to 183 of the Criminal Code, if you have a look at the Supreme Court of Canada, they're saying that, yeah, it may be a good idea, this, but the present provisions of the Criminal Code under 184.4 apply to any unlawful act. And so what we're restricting that to 183, so I think providing some clarification and making it a little more definite, I think is a step in the right direction.
Now, you'll excuse me if this question is simplistic, but I'm not a lawyer, so you'll have to bear with me, because
I should hold that against you, Mr.
Pardon me?
And I would object to anybody who did. Please.
Yeah. No, and it's just really for my edification here, because under the definition of police officer, it doesn't say an officer, a certified officer employed by a municipal force, a provincial force, or the RCP. It says constable or other person employed for the preservation and maintenance of the public peace. So there's no danger that would be interpreted. That could be interpreted to mean the security guard, that the private security guard employed by a municipality to patrol the streets at night because they're not getting sufficient, regular police force coverage, which we see in communities across.
One of the good things about the use of that term is it has already been interpreted a number of times by the court, so it does not apply to those. And if you'll see in the that the definition is also defined in other sections of the Criminal Code, so they have a pretty good idea of exactly who is and who is not a police officer.
See, I learned something, Mr. Chair. I learned something. That's part of my legal education. Now, in terms of applying 184.4 to 183, I understand that you want to make it consistent with the way the other sections 186 and 188 function. But here, if you read the Supreme Court judgment in say, it says the list of offences in section 183 is itself very broad. However, Parliament chose to focus upon an unlawful act that would cause serious harm. We see no reason to interfere with that choice. So, I don't understand why we have to make it consistent with 186 and 188 when the purpose of 184 seems to me, as a layperson, different from 186 and 188.
Very interesting point that you're making, but it seems to me that if we are intercepting somebody's communication without prior judicial authorization, there should be a very strong onus on the individuals who are doing that to ensure that that is appropriate. And so I actually like the idea of actually defining exactly which offenses this applies to, that it's not just to any unlawful act, which could be very broad. And again, we went beyond what the Supreme Court said. We said we're restricting it to these, to 183, as you can see, are very serious crimes, for the most part, right, and they're all spelled out. And so, again, I think it's a better way of doing that. Okay. And again, we didn't have to change the definition of from peace officer to police officer, but I think when you are doing something like this, I think it is important to be as specific and as definite as possible.
Okay, because you would think that the Supreme Court would want to tighten it as much as possible, but they said we see no reason to interfere with that choice. But anyway, I'm not going to belabor the point, and those are the only questions I have.
Sir, thank you for the questions. Thank you, Minister, for the answers. Our next questioner is from the Conservative Party, Mr. Armstrong.
Chair and Minister, thank you for being here. Just a couple of quick questions just about process. We talked about three different components of the criminal code: 186, 188, and 184.4. 188 and 186. Could you just discuss the difference between those two? And 188 is a more speedy way to get a wiretap and other methods used by the police force. But what's the difference between those two, and why is 184.4 needed as well?
Again, we're talking basically about three different situations. In the ordinary circumstances, you would make an application for a wiretap. It would be under 186. If part of an investigation, for instance, of organized crime, the information would be presented. There would be a judicial determination whether this is reasonable, under what circumstances, what are the parameters, who, how, and where. And so this can be a considerable, lengthy, well thought out process. That is the usual process. You could have a situation where you need a wiretap, where they need a wiretap and they don't have that opportunity because of the urgency of it to make that formal application to the court. So that provides, among other things, that you could pick up a phone and get a law officer, somebody who's authorized to do this, to provide this, to give you the okay over the phone if you had to have that, okay? That's the second one. I call that the emergency wiretap provisions. That's section 188 of the Criminal Code. 184.4 takes that one step, that emergency, one step more, that there is possible imminent harm to people or property, that there isn't time even to start phoning somebody and getting somebody and explaining and making that type of an application. You have to have the information right now. And one of the cases, I mentioned the Riley case and the Say case, they had to have that information immediately to try and do their best to protect the individuals, and there really wasn't time to do anything else. So you have the three categories of them. For the most part, it's the regular wiretap under 186, again, that you make the application, but depending upon the urgency. But again, what we're doing with 184 is basically bringing them into line with the other two sections, so that there is accountability and that there is judicial involvement with this. So that's what we're doing under this particular section. And again, I think it complements those other two sections here that I just described.
Yes, and all the changes that are made in C-55 really are just to strengthen the privacy components of the legislation to come in compliance with the Supreme Court.
It is. We are complying with the requirements of the Supreme Court of Canada, but as I said, and I pointed out to your colleagues across the aisle, that we've gone beyond that in limiting it to a certain number of offenses, the 183, changing the definition of a peace officer to police officer, and extending the notification, going on beyond just provincial attorneys general, have the federal Minister of Public Safety, let him table that report as well.
Are you confident that the bill, the way it's written, can be applied to future technologies? Is it broad enough to do that as well? If it lose, we're tightening up the privacy concerns, but also can we adapt to future technology?
I think it is. I think it's broad enough to include, as Mr. Paragraph pointed out to me, two people in a room, or whether it's, they've gone beyond telephones, as you know, in terms of communicating. And so I believe it is broad enough. And again, that's one of the things that we have to do with the legislation. And I've been before this committee many times. We have to make sure that it's up to date, that it actually covers what's taking place out there, that it's not drawn so narrowly that it doesn't capture, where technology and, quite frankly, where the criminal element goes, because they don't wait. They're not confined by present-day technology. They're always looking for other ways to accomplish their ends.
Great. Thank you, Minister. That's my last question.
Thank you, Mr. Armstrong. Thank you, Minister. Mr. Mai from the New Democratic Party.
Merci, Monsieur le Président. Merci.
Thank you, Mr. Chairman. Thank you, Minister. I'd like to continue in the same vein as Madame Boivin regarding what the Canadian Bar Association had to suggest, the recommendation relating to notification. At this point, it looks, in the way that the bill is drafted, only those interceptions conducted where there would have been charges or it would have been brought before the courts, there would only be in those cases where the people who were the subject of the wiretap would be advised. One of the concerns of the Bar Association is, why not go further to ensure greater transparency and also include people, cases where it wouldn't have led to charges or arrests? Why not further transparency on that front?
The notice is anyone who is the object of this interception, and it's not dependent upon whether any charges or subsequent charges are laid or not. They are entitled to notification.
Just to specify, 195.1 relating to reports on point C, interception under 184.4 if it has to do with an offense for which there may be prosecution from the Attorney General of Canada. So this is reports after the end of the year, point C for 195.
At this point in time, we're paralleling the reporting requirements that already exist within the criminal code with respect to section 86 and 188. And indeed, as you can see, we're actually going beyond that in terms of having the Minister of Public Safety table reports with respect to 184. And so, again, I think this is a considerable step forward in terms of providing the appropriate safeguards.
En fait, ce qu'on demande, c'est pourquoi.
I won't hold that against you.
Point in my discussions with Mr. Paragraph. I mean, this is in direct response to the SAY decision. It's not supposed to be. It's not intended, as I indicated when I introduced the bill. It's not intended to be a complete overhaul or an examination of this particular area, but it responds specifically to the Supreme Court of Canada decision, and as I say, it goes beyond the safeguards required in that particular decision. And so, it is what it is. It doesn't hit everything.
C'est quand même une inquiétude qui a été soulevée par
It was a concern raised by the Canadian Bar Association and by us as well. To get back to offenses under 193, you say there are only some offenses referred to in order to get an authorization. When you read 183, there are about 4 or 5 pages worth of lists, and everything from telemarketing, misleading telemarketing, a whole host of other cases. Are these urgent cases? I understand that in some cases it is urgent. We have to take action, and there are points under Section 183. But if you look at that entire Section 183, there are some very broad terms there, and I mentioned some, but I could go in greater detail. Do you not think we should have a more precise list of the sections to have a better understanding that there are no mistakes here?
Again, as I say, the existing law is that it apply to any unlawful act, so we've restricted it. But the other provisions with respect to the imminent harm that comes to property or individuals kick in, you see. So it's not critical. It's not absolutely critical exactly what it is the offense is, other than the harm that is feared by the police officers. That's what it is. So I think it's appropriate, as was discussed in the case, to limit it to the list of offenses in 183. But again, the other provisions for this section to kick in have to be there. Those elements have to be there for this to apply.
D'accord. Et aussi lorsque on...
Okay, and now
It's a question. Okay, if you have a wiretap or something, what is it that also as part of that to make this necessary for this emergency wiretap? That's what it is.
Okay. How much time do you have?
I'll give you another minute.
In a minute. Okay. For lorsque
to arrive at this bill, there was Bill C-30, as my colleague mentioned. We're quite pleased that the government realized the mistake that was about to be made, and we now have C-55. There was also C-12 at one point, provisions that were to be enforced. Has there been any follow-up on that?
I'm proceeding with this particular bill, Mr. May, at this particular time, and that's the bill that we have before him. But as you probably are aware, in your time here in Parliament, there's been no shortage of justice legislation, and we'll have other pieces of legislation. But today, this bill is completely focused on the Supreme Court of Canada's decision in Say.
Thank you, Mr. May. Thank you, Minister. Our next question from the Conservative Party is Mr. Seaback.
Thank you, Mr. Chair. And Minister, I only have one question. I know it's been touched on today by both Madame Boivin and Mr. Scarpaleggia, but I want to get a little, maybe drill down just a little bit more. The definition of peace officer in the section of the legislation, it mentions other persons employed for the preservation and maintenance of the public peace. Do we know who would be sort of grabbed within that catch-all phrase, and is it coming from a certain section of the criminal code? Do we?
Well, peace officer, if you have a look at Section 2 of the criminal code, sets out a wide range of individuals who, as I say, I indicated, I mean, starting with the municipal government, to make sure we don't just have mayors, we have reeves as well that are contained with that. The pilot of a plane, for instance, individuals under a dozen different federal statutes come within the definition of a peace officer. And again, I guess the question you'd have to ask yourself, is it absolutely necessary that they would have this particular power? What is it that they are doing that they would have to intercept the private communications of an individual? And I think you might come to the conclusion and say, I can't imagine some of these individuals, how and where and why that would be necessary for them in their roles, their respective roles. And so I thought, and I believe, and I hope that it's your opinion as well, by your analysis of this bill, that it was appropriate that we defined it a little more clearly as to exactly who it is that has this ability in an emergency situation to prevent imminent harm, to intercept the private community, otherwise private communications of individuals. And so that, I think, was very important. And again, it was one of the things we didn't have to do, but it seemed to me that it made sense. I mean, one of the things that you will notice about the Say decision when you go through, that there is, sometimes we call it obiter. I mean, there are thoughts and discussions that take place on a number of different areas, but they do give us sometimes, direction on where we might go, so that we're not challenged at some future case on some of these issues. And so I think it's entirely appropriate to have a look at those suggestions and incorporate them into the bill, as I indicated to Madame Boivin, that we've gone beyond, we've done what they wanted, but we've gone beyond that as well. And I think, again, and I hope it's your analysis looking at this bill at committee, that you will agree as well that we're better to define exactly which unlawful acts we're talking about. We're better to define exactly who it is that can and should do this. And yes, it is a good idea idea for provincial attorneys general, but it's good for the public safety minister as well to do that. You notice I didn't put justice minister in, I got public safety minister in, but he can take on that responsibility, and why not? I think it's a very good idea.
Great. Thank you, Mr. Seebeck. Thank you, Minister. Our next question from the New Democratic Party is Mr. Marsden.
Well, thank you, Mr. Chair, and Minister, welcome, and to our officials as well. In my past life, I was part of this equation. I worked for Bell Canada for 22 years. If somebody called in and said, I think my home phone's tapped, I went and did a test on their line. If you called in and said there was noise in your line, I would type into the computer your number and it would come up, and I would listen to seconds of your conversation to see if there's trouble there. And my point of that is there's probably some instances that Canadians are unaware of the fact that somebody here and there is listening. Obviously, that was for a very different purpose. And what we're talking about here is what I consider, from what you're saying, a very exceptional situation. And I think, in fairness to the government, you've made a reasonable effort in this. Canadians, in the society we live in with the electronics and all of the conspiracy movies you see where the government, which is usually U.S. in the movies, are intruding in people's lives. You can understand why people would be concerned. And the question, even though it's been touched on 3 times here, we talked about emergency wiretaps, which has a connotation to it of a hard wire onto a phone line, and that's it. Just for the record, I want to put before the committee that would include cellular communications, text communications, which the children of our generation are wearing their thumbs out doing. Exactly. But I want to be very, because you had used the term to intercept communications, and I took it to that it took all of that in. It does. I would say I think it's important. I know that we just received the Bar Association's offers of suggestions, but there's 3 in there. One of the things they talked about that caught my eye is the fact that in the special circumstances of putting the wiretap on, that the evidence garnered during that might be thrown out in court. And that's something I think somebody should take a look at. This is their reading, not ours. So
I do have a look at what they have to say, and indeed all individuals who make suggestions. But the bill is very specific and confined to what it is that we are trying to address at this particular time. And again, you can see by the title that we put up,
amend the criminal code.
It's a response to the response to the Supreme Court of Canada decision in RV Say Act. Okay, we put it right in there at the beginning of the bill. That's exactly what it is we're doing. We're not trying to get into other areas, but I mean, you touched on a number of points, and this was raised by my colleague, that it's not confined to one type of communication. It's all communication where there is imminent or the possibility of serious harm coming to someone if that information is not given to the appropriate authorities. And so, again, I appreciate all inputs on these, but again, this bill is what it is. It stands on its own.
Well, my intent was to put it on record so that people could reflect back on it in due course, because sometimes people, even though it's clear to us on paper, once it's passed, somebody starts raising, it's doing this and it's doing that. It's better I think, to have it on record.
Good point. That's an excellent point.
Thank you, Chair.
Thank you.
And thank you, Minister. Our next questioner from the Conservative Party is Mr. Albus.
Thank you very much, Mr. Chair, and thank you, Minister, for your presence here today. Certainly, I hope that we can all support this particular bill. After reviewing some of the papers that the Library of Parliament has done as far as analysis, and then coupled with your testimony here today, I think it's very important that all parties support this. We all know that law enforcement at times requires the ability to respond very quickly, and in situations where there's urgent circumstances. Minister, you mentioned specifically kidnapping, hostage-taking, bomb threats, are just some of the few examples where urgent actions are expected of the police to protect innocent victims and maintain safety. A good example, Minister, from my home province of British Columbia is the kidnapping of a 23-year-old Vancouver resident, Graham McMinn, in April 2006. And the prompt response by the Vancouver Police Department in using all the legal resources to safely return Mr. McMinn to his family serves as a reminder as to why useful amendments such as Bill C-55 are in order, and so that you can continue to protect the public. Now, this legislation responds directly to the guidance from the Supreme Court of Canada by adding new privacy safeguards of notification and reporting. You've alluded to it in a number of your testimony and comments to the committee, specific Section 184.4 of the Criminal Code. Minister, is there anything in this bill that is not related to adding more safeguards beyond the response to the Supreme Court?
When you get an opportunity to have a bill like this, we do try to make sure that anything of a technical nature that can or should be placed into it is done. For instance, the department works very hard, as you know, to make sure that the English and French translation are absolutely consistent. And so you will see references in there where there's been slight changes to make sure, because this is an ongoing process that we have in this country, to make sure that they're absolutely consistent. We sometimes update the language in these bills. There's a reference, I believe, to the minister, and they use it in terms of masculine. I mean, you can, a man or woman can be, of course, be justice, can be a minister, and so we update the wording in there so that it's gender neutral. I mean, that's basically what we do. And so what happens is you might be taking legislation that's been done many decades ago and find that they're not gender neutral. But what we like to do is when we bring forward a new piece of legislation to clean up something like that. And I think that's entirely appropriate. But again, the bill is, as I indicated to your colleagues across, there is a very focused on the decision. But again, whenever you have a piece of legislation, you want to make sure things like either gender neutrality or consistency between both official languages, and so you'll see slight modifications with respect to that.
Great. Thank you, Mr. Chair.
Thank you, Mr. Elvis. Thank you, Minister. Mr. Jacob from the Democratic Party.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. Thank you, Minister, for being here. My first question is this. It has to do with Bills C-55 and C-394. We've taken for granted that it would get that they would receive royal assent shortly. If they do, would these amendments, or rather what amendments would be needed to ensure consistency in the criminal code?
You know, with all respect, Mr. Jacob, I'm not quite sure where you're going with that. Yes, we would, with the passage of this particular bill by the House of Commons and the Senate, and with royal assent, we want this to come into effect as quickly as possible. We're facing a deadline of April 13th, and again, that's what the totality of this bill, this is what it's all about. You mentioned, I'm sure, was it some other bill, did you say? Or perhaps you could give me a little bit more lead on that.
Oui.
Yes. Under 196.15A refers to extension of notification for offenses described under 467.11.12, three types of offenses committed by criminal organizations. However, this bill, Bill C-394, which is also going to be studied by this committee, provides another offense relating to criminal organization, in other words, recruiting an individual to be part of a criminal organization, which would correspond to 467 of the code. Is there a reason why the proposed offense would be treated differently than the other offenses committed by criminal organizations when it comes to an extension of the notification period? And if not, what would be the required amendments that we should bring?
Turn this over to Mr. Peregrine.
Thank you. As I understand the question, It's whether there should be some concordance between this bill and another bill that's before Parliament. And if that bill is passed, whether certain references in the criminal code already to certain provisions of 467 should also make reference to this, to whatever is passed by, is it 394? The other bill would have to make provision to make any consequential amendments. This bill cannot assume that another bill will be passed. It'll have to be that other bill which makes consequential amendments to other pieces of legislation before Parliament.
OK. Donc, ma deuxième question.
So my second question, do you have some concerns from a constitutional standpoint regarding the fact that the information intercepted pursuant to Section 184.4 be used for other purposes than to prevent an offense being committed and to prosecute in the case of an individual?
Thank you for that question. That's covered in this bill by the safeguards that we have put there, that we want to make sure that, number one, the individual gets notified, the individual whose communication has been intercepted, that this is part of a report not only by provincial attorneys general, but the Minister of Public Safety at the federal level. And again, these are entirely appropriate to make sure that there is some transparency and indeed accountability with respect to this, to make sure that this is used for exactly what is contemplated, and that is to prevent serious harm, physical or to the person or to property. And so, again, I'm confident that with the safeguards that we have placed into this bill, that this bill will work well. I have no reason to believe that it was being abused prior to this, quite frankly, and that's not what the Say decision is all about. The Say decision examined the use of 184.4 and said, yes, we can see why that this makes sense to have this power, but we're saying is have these additional safeguards, or at least one safeguard afterwards, so that you can have that accountability. And so, again, I think in totality, I think we can go forward with confidence and say that this important, necessary tool that law enforcement agents, in my opinion, have to have will also have the appropriate amount of accountability and safeguards in it. I think it strikes a very reasonable balance, and again, I'm looking forward to the support of everyone on this.
Is that it, Mr. Jacob? A very short question.
OK. Très brève question.
Very brief? Okay. Thank you, Mr. Chairman. I don't have a brief one.
Thank you, Mr. Jacob. Thank you, Minister. Our final questioner with the Minister is from the Conservative Party, Mr. Wilkes. And your time is 5 minutes, which includes the answer.
Perfect. It won't take that long. Thanks, Minister, for being here today and being the author of 2 wiretap investigations. I can tell you that it's what our Canadian law is very good. And I'm just curious, though, I wonder if you could go on a little further with regards to the April 13th deadline. What happens if we don't meet the deadline?
It's not good. I mean, because if we don't have this in place in the next little over a month, that particular section, 184.4 specifically, becomes unconstitutional. And if you had a situation, as I outlined in the Riley case or the Say decision, where somebody, for instance, whose life is in immediate danger, you're not provided the vehicle, the means by which that interception can take place. And so it's it's very important that we move on these. And again, I appreciate the fact that sections like this are not struck down in and of themselves. I mean, it gives time for Parliament to have a look at these provisions and make changes. And so that's the opportunity we've been given. And so again, this bill has moved quickly through Parliament at second reading, and again, with your analysis, we get this back into the House here, and I'm confident that with the cooperation of everyone, we'll have this in place, and this will continue to be the law in Canada. Because, as I say, the Supreme Court of Canada itself did not strike down the section itself. All they're saying is that, yes, this is reasonable to have these powers, but you have to have a safeguard that goes beyond that. And that's exactly what this bill does, and goes beyond and takes the recommendations and suggestions to heart and have placed those in the bill as well.
Thank you.
Okay.
Thank you, Mr. Wilkes. So I want to thank you, Minister, for joining us today and talking to us about Bill C-55. As you know, we will be studying it with witnesses on Wednesday in the for the first hour and maybe a little more, and then we'll be going clause by clause. So thank you very much, and we'll ask the officials if they would stay for a few minutes if people have questions. Maybe, do you have questions? There are going to be some questions, so we'll continue. So I'll suspend for 30 seconds while the minister leaves. So we have our witnesses here with us from the department, and I appreciate them staying. We have some time if we need them, and we have one questioner for sure, Madame Beauvais.
Je passerai jamais par-dessus cette possibilité-là.
I'll never give up that option, given that we have such brilliant individuals from the Department of Justice here with us. We'll take advantage of the opportunity, especially when we are in a bit of a rush with the bill. I've taken note of what the minister said. We're quite conscious of the impact of the R versus Say decision and what would happen on April 14th if we didn't have this bill passed. That said, my question to you is this. You're working on C-55, and how long, in fact, have you been working on C-55?
Là, on a déjà introduit les réactions.
We already introduced reactions in Bill C-31, and then it was C-50. But these reactions or decisions were lower court decisions, and then you had C-30. The Supreme Court decision came down on April 13, 2012. So we're working in response to the Supreme Court decision since then, and have been. So there had been work done to respond to lower court decisions in the past, because decisions from BC, Ontario, and Quebec, these courts had said that we needed to consider that section of the Criminal Code because there were constitutionality issues. I understand that, but perhaps you did not understand my question. C-55, this decision is this bill is a reaction to this Supreme Court decision, R versus Say. I understand that C-55, I know that the government had C-30, there was C-12 beforehand. There were a number of bills that had been undertaken, in fact, to try to address the problem raised as a result of the R versus Say decision. The government said it was withdrawing C-30 at the same time as it put forward C-55. And in actual fact, I think it was February 11th, 2013, which is barely a month ago, that Bill C-55 was introduced by the Minister in the House. It was then sent to the committee on February 25th, so that's quite recent as well. As you were working on C-30 and other bills, C-55 was not in your line of sight. My question is, when did you start working on C-55? In other words, the drafting of C-55.
Le texte qu'on a dans...
The draft of C-55 was in Bill C-30, and then previous to that, C-50, and then C-31 prior to that. The only change we brought since the C-30 wording was to include that limitation regarding police officers. That's something the Supreme Court had indicated would be a good idea, and the government wanted to respond to that. And you wanted to close off those potential loopholes or problems that might arise under C-55. So, from what I gather, if you thought under C-30 everything looked rather good, but once C-30 was no longer in the picture, you needed to find something additional, something else to respond to the Supreme Court's concerns about unconstitutionality. So it seems quite clear to me on that front. Now, when it comes to justice issues, and when you look into issues like in the case of R versus Say, which says that it's not charter compliant, that Section 8 is not charter compliant with respect to interceptions, that they're not compliant because there was this lack that the minister was referring to. What did he call it? I'll find the expression. to ensure that it is constitutionally compliant, making sure that people were made aware, ensure reporting. What kind of a legal test do you undertake to make sure that these drafts respond to R versus C?
In this case, it was very easy to know what would be compliant because the Supreme Court of Canada told us. The Supreme Court said that a notification requirement would meet the constitutional.
But they didn't say how many days. They didn't say. So what made you decide that 90 days and an extension of up to 3 years would be? How do you come to that justification?
Because that was the existing law. The 90 days is the existing law for the ordinary wiretaps. The wiretaps under Section 186. Those provisions already have notification requirements of 90 days and possibility for an extension.
Renewal.
So basically, what happened in terms of the notification was we just used the same model, same wording that existed for the judicially authorized authorizations. The Supreme Court of Canada even noted that there were previous attempts by the government to address the same type of problem and had proposed notification requirements. So the Supreme Court of Canada was aware of the previous bills, what has been proposed, and the court made note of that fact that said there may be other ways to correct this constitutional deficiency. The government has proposed 2 or 3 times already to provide a notification requirement, and the court said a notification requirement would make the law compliant, constitutionally compliant.
Okay, so you were reasonably. That's basically right. My question. You're reasonably satisfied that it is charter compliant. Yes. You've done the test. You've seen the jurisprudence on the equivalent clauses before and so on. So all that work has been done. We can be assured that it has been done.
Yeah. Yes. We basically follow the advice of the Supreme Court. And
I know I'm bugging you all with my question about the report, but what is wrong on a transparency basis to have the Minister of Public Security report to Parliament on all the interceptions, even those who have not gone so far as having a court case with it, because actually those are the ones who bugs me, because it tells me somebody was under wiretap or whatever interception and nothing came out of it, and we don't know. So it might be interesting for Parliament to know how often it's been used and how many of those have s'est rendu jusqu'à des poursuites criminelles.
Led to prosecution.
I think on this issue we would disagree with the Canadian Bar Association, because the provision in the bill actually requires, and this is subsection
195.
This is the amendment to 195, subsection 2.1a, says the number of interceptions made. So that's all interceptions made. So it's not just the ones that resulted in a charge. And then paragraph A of that subsection, paragraph D of that subsection says the number of notifications given under subsection 196.1.
So you say it's included?
It's included because there's already an obligation to report all interceptions and all persons who were notified, whether or not what the report does. It goes beyond that and says, can you also
from the report we'll be able to say, well, there's 300 done,
right.
And those who are detailed with criminal offense charge, we can do the subtraction and say, oh, well, there's 100 that were did not. Okay, thank you.
Any further questions of the officials? Seeing none, thank you very much for your attendance. Thank you for supporting the minister, and good work on this this bill. We will be, as I've said, we'll have witnesses on Wednesday to discuss this. Then we'll be doing clause by clause. Just before I close, we have 2 witnesses confirmed. We may have 3. I will be a little bit flexible on the time because there's only 7 clauses, and that we make sure everybody gets a chance to ask questions of those witnesses, and then we'll do clause by clause, and we'll go forward from there. With that, thank you very much, and I'll adjourn the meeting.